Today on Law Weekly, we'll focus yet again on the gale of impeachments blowing across the country. I had the privilege of getting the insights of a legal practitioner and a former senator in Nigeria's Fourth Republic, Senator Olabiyi Jaye. And as the Judiciary Staff Union calls off its industrial action, some legal practitioners shared their views on the implications of the strike, which has paralyzed activities in the courts across the country for the last 3 weeks. The program is Law Weekly on Channels Television, and I am Shola Shuyeli. From Adamawa to Nassarawa, Ebonyi and Enugu, there's been no let-up in what appears to be a season of impeachments. And if you've been following the trend of events, the politics in Nassarawa State, in Nigeria's northwest region, is particularly a hot topic right now. Here's the latest update from there.
The CJ should dissolve and reappoint fresh persons to work in terms of investigation of the 16-count allegations on the governor.
That is the stand of the PDP lawmakers on the panel set up by the Chief Judge of Nassarawa State to investigate allegations of misconduct on Governor Tanko Almakura. Just a day before the panel is expected to resume its sitting and they make their reasons clear.
Guidelines is still with the Assembly, so committee can now assume sitting. Since they are not properly appointed, we've not given them guidelines to operate.
Meanwhile, the APC, the governor's camp, has frowned at the move by the PDP lawmakers, and Governor Almakura's media advisor speaks on the activities of the lawmakers.
The said resolution was purported to have been hinged on the notion that the 7-man panel was constituted with people of questionable character. The sitting of the House, as far as government is concerned, amounts to a mere congregation of concerned members of Nassarawa State House of Assembly because it is not in conformity with any democratic requirement. This is because no rule of the House permits the sitting of the House of Assembly anywhere in the state to conduct legislative affairs of the state. This sitting, therefore, is ill-motivated, illegal, and of no effect whatsoever.
Done with the sitting of the first day, here are the panel members, but they appear unperturbed by the resolution of the lawmakers on dissolving them.
With regards to the resolution of the House, we cannot say anything. We cannot say anything. It does not concern us. It does not involve us.
They also looked resolute and clear on how they hope to carry out their duties.
Our meetings will be public. It will be public sitting. Every site, all parties involved in this investigation would be given opportunity to present its case, call witnesses, put in documents, and the parties may be represented personally or by legal practitioners of their own choice.
It's a new twist in the Nassarawa State impeachment saga. The Chief Judge says he has done his job by setting up the panel. The lawmakers are not happy with the panel, but the panel seems unconcerned with the lawmakers' worries. A stalemate we have on our hands in this matter. But now we just have to watch and wait to see how the events of the coming days unfold.
And to discuss the legality or not of some of these events, I spoke with a legal practitioner, former Senator Olabiyi Jaye. He's 81, still very agile, active and passionate about the politics of Nigeria. I caught up with him at his law firm in Lagos, and we spoke about the politics and the law of the impeachment exercises.
I want to get your reading of all these impeachment moves that we're seeing blowing across the country. There are some people who think that it is political rather than legal. Do you agree with that thinking?
If you look at it critically, you find it looks like more of political wine in legal wine skin.
A political wine in a legal wine skin. Why do you say that?
That's what it looks to me, abracadabra. Because they are following the procedure. The procedure of Section 188. There are only 11 sections of it. How the the holding action will start with the House of Assembly or Rep or whatever, legislative chamber, and then 1/2 majority believe that and express the view that the governor has some impeachable offense. If 2/3 majority agree it is so, they pass their motion to the chief judge, who will empanel a group of 7 people of impeccable character, not identified with any political party or in any public service, you see. And then whatever they investigate, then they report back to the House. It appears so far, what is happening in Nassarawa, they are following state by state that legal procedure. But that does not mean that the bird that is dancing on the road, the drummer, is not in the nearby bush. I could see the political, because I mean it's a trend. If you look at the type, the particular states affected, there are states in opposition to the federal government.
With what the law says in Section 188, because I know you made allusion to that, it appears that the lawmakers can begin an impeachment procedure on whatever they consider as misconduct. And there are some people who say, like you said, there could be political strategies, political orchestrations. There are some people who say that if we give them that kind of unfettered discretion, that won't the executive become easy prey in the hands of the legislature?
No, there's a check and balance there.
Okay.
That's a check and balance, a booby trap for the House if they want to go beyond the part. If they say frivolous allegation they have against their governor, the panel that is constituted and expected to be highly independent and people of integrity, they will find a loophole there. If the excuse is that the man doesn't always visit us in our chambers, that would, I mean, what's an impeachable offense? It's a thing that the common sense interpretation will be able to say, yeah, that's grave enough.
So we don't
you can't say that.
Spell it out.
It's not spelled out.
Yes.
But at least common sense will show what exactly will look like impeachable. As I just give you that ridiculous example. Since we came here, the governor has only been here twice. He has not visited us. Therefore, we want to impeach him. You know, if anybody says such a silly thing, the panel will be able to say, we dismiss it offhand. They don't make anything. But if it is really a serious matter enough, and you cannot categorize what and what will be very serious matter, if they find proof that has been embezzling funds or has committed really grievous, like shooting somebody point blank, murder, or some atrocious behavior, then the panel will be able to say, yes, this case is made. And you know, the panel will report back and say, your case is not made. That is, we find nothing impeachable in the character of Mr. Gov. That is the end of the matter. So that's the check and the balance there.
It's interesting you mentioned the chief judge now, because I want us to turn our attention to Nassarawa State, where the lawmakers have asked the chief judge to reconstitute the 7-man panel. Do they have the right to determine the way and manner? I know the chief judge has the discretion to set up the 7-man panel, just like you said. Can they determine or tinker with the way that he exercises that discretion?
I do not think they have that authority to dictate to the chief judge who and who may be. That it is the discretion of the chief judge. Okay. If they are not satisfied, then they can go to court for interpretation. In this case, we have no confidence into the judge. The chief judge is of the discretion, so the opinion that Mr. A or Messrs. A and B out of the 7 members of the panel are, as far as we are concerned, persona non grata, or they have such record that the chief judge may not know. Okay. We would not like them to be on the panel. We have no confidence. It is the court now that will say, well, that they make a case or not. Or that they cannot dictate, they cannot compel the discretion of the chief judge of the state.
So what remedies are available to them if they are not comfortable with the kind of panel that the chief judge empowers?
We'd like to see what court will say to say that the chief judge has not, because that's like impeaching the chief judge himself. If any high court in the state will say what the chief judge has done, discretion has been misapplied, we will wait and see. It will be interesting.
But then it also means that in the exercise of his discretion, the CJ, the chief judge now, if he is sympathetic to the governor, he could empanel a panel that is sympathetic to the governor and will do the bidding.
How will you? It is its discretion. The law doesn't say pick people who are the but himself, a chief judge must be very careful what he does, because his own character may be put in question. And there's always a higher authority to look at what he has done. Yeah, but it will be, he who has asked must prove. It will be very hard for the assembly to say, this fellow is not a fit and proper person to sit. It's they who must who must prove, and that won't be very easy thing to prove. What would they say against somebody already nominated? Unless they say he has a criminal record that maybe the chief judge didn't know about, in which case, if they establish that maybe the chief judge may say, make a point, this par inquiry, this is a decision I took without knowing certain facts also.
Okay, so at the last stage, they can get the chief judge to reverse himself.
I don't think, well, if it is apparent on the face of it, and even the chief judge himself may decide on this, it's his discretion. But if they show proof that this fellow you pay, don't you know, here is record that he was jailed in Anambra State for stealing a cow. So what, 10 years ago or something, okay, you want to put that matter before that, so then he might in his discretion say, all right, but it won't be the whole panel that will panel all the 7.